evening and welcome. My name is Carolyn Evans. I'm the Dean of the Melbourne Law School, and on behalf of my colleague, Professor Adrienne Stone, Director of the Centre for Comparative Constitutional Studies, and indeed all of my colleagues and our students, it's my great pleasure to welcome you here this evening for the lecture on constitutional reform by the Honourable Nicola Roxon, Attorney-General of Australia. This address also marks the commencement of our conference on recent developments in constitutional law, and can I issue a particularly warm welcome for those of you who've come for that conference, including those who've travelled, I know, quite a long way to be here. I begin by acknowledging that we meet on the lands of the Wurundjeri people of the Kulin Nation and pay my respects to their elders, past and present. Well, tonight I have the very pleasant task of introducing the Commonwealth Attorney-General, the Honourable Nicola Roxon. The Attorney-General, as we never stop telling people, graduated from this law school and this university with degrees in arts and law, scoring top marks in law so that she was the Supreme Court Prize winner for that year. Many of our current teachers remember her as fiercely intellectual, a formidable personality, and none appear in the least bit surprised that she's gone on to achieve so much in her career. Prior to entering Parliament, the Attorney-General worked as Associate for Justice Gaudron, then of the High Court, as a lawyer at Maurice Blackburn and as an organiser at the National Union of Workers. However, it is in her time since she entered Parliament as member for Gellibrand that she's become best known. She held many shadow portfolios before the ALP was elected to government. Since that time, and before becoming Attorney-General, she was, of course, Federal Minister for Health and Ageing, where she oversaw major reforms to Australia's public hospital, primary care and preventative health systems. It's particularly worth noting that in her roles, both her roles as Attorney-General and as Minister for Health, she's played a really significant role in the move to greater regulation of tobacco, particularly through the plain packaging laws. And if I could perhaps make a quick side note, a number of colleagues here at the Law School have also been engaged in that important area of public policy development, lending their expertise in areas of constitutional law, intellectual property and world trade, both individually and through our collaboration with the Cancer Council. Last year, the Attorney-General was recognised with the World Health Organisation Award and World Health Organisation Director-General's Special Certificate for her achievements. It was said in the citation that it recognises Minister Roxon's unwavering leadership in the field of health and describes the proposal to introduce plain packaging as a bold and breakthrough approach. Her actions, it said, have inspired political leaders in many, many other countries to take strong, calibrated and decisive action. It is, of course, not on that topic that she's here to talk to us tonight, but another very important issue, that of constitutional reform in Australia. And as a constitutional lawyer myself, I must admit to having some interest in hearing what we will be about to hear from the Attorney tonight. We're delighted that an alumna of ours who's made such an important impact nationally and internationally can be with us here tonight to discuss this important topic. The Attorney will present her paper and then she's kindly agreed to take some questions afterwards. They will be chaired by my colleague, Professor Stone, and could I take this opportunity to acknowledge Professor Stone's leadership in organising tonight's event and also the conference that will follow it. Could you please note that both the lecture and the question time will be recorded. It's now my great pleasure to call on the Attorney-General, the Honourable Nicola Roxon, to deliver her lecture on constitutional reform.
Thank you very much for that kind introduction, Carolyn. I'm very happy for you to tell the world that I'm a student of Melbourne Uni. I've always been very proud that I got such a good education here, and I suspect many of the country's lawyers are now pleased I indeed did get that good education. Can I also acknowledge the traditional owners of the land that we're meeting on and pay my respects to their elders, both past and present? Can I acknowledge the Dean, Carolyn, who's just made that introduction, and note, having just sat briefly in her office, that I walked past the wall of fame of those deans that preceded her, and there is something that is quite different about your current dean. And Carolyn, I'm pleased that we have now the first female dean of Melbourne University, and I'm of course very proud to be the first female Attorney-General of the Commonwealth. I did note there, and I understand that he's with us in the audience, that the Dean of the time when I was a student, Michael Cromlin, is here, and I know that there are very many other past and present members of the judiciary leading professors, of course, of the law school, I need to be biased and mention two good friends of mine who are both associates at the same time as me at the High Court, being Professor Adrienne Stone and Simon Evans. I am very pleased, Adrienne and Simon, that the Superior Law School has lured you both from the north, and I'm sure that the students of Melbourne Uni are very pleased too. It is nice to come back to your own university to provide a lecture like this, and particularly to speak as part of the conference that's kicking off tomorrow. I would like to tell you that as a student at this law school 20 years ago, that I always knew that I would be back here as the Attorney General. But in truth, despite those kind words that Carolyn says my previous lecturers might have passed, I can tell you no such thing at all. I am very pleased, though, with the quality of the education. I do rather wish that I might have kept a few more of my notes because, of course, that education is being called upon in lots and lots of different ways. I do seem to run into the Melbourne University diaspora all over the place now. Sally Walker has just become Secretary-General of the Law Council. Greg Craven seems to be in the papers even more than I am. Hilary Charlesworth was recently addressing a meeting of attorneys. Fred Ellinghouse, still with you here, and Ted Wright have been lobbying for contract law reforms. And there are no small number of past students who are in the courts often, I might say usually taking the Commonwealth to the High Court for something or other. And I have to admit that there are occasions when I wish Melbourne University didn't educate those people quite so well. They do seem to have a fairly good record against the Commonwealth before the court. Given I'm here at a constitutional conference, particularly, I know that there are also a broader selection in the audience, but for those academics who are attending the conference, I suppose there's nothing that they love more than complex High Court decisions, and will delight tomorrow in making predictions of the future. But I thought that the value that I might be able to add in a speech like this as the Attorney General and as a politician is to provide a different sort of practical perspective on the issues that we face, and to talk a little bit about how modern government runs, the way the Constitution and the court have an impact on what we do each and every day. Since Federation, of course, constitutional law has been built on a battle of ideas, disputes between levels of government and the inherent tensions that there are between arms of government. Constitutional reform has been affected not just by the direct changes to the text of the Constitution via referendum, but also through changing interpretations, fiscal power, approaches to government, taxation revenue sources, political realities and community expectations. And our constitutional arrangements have undeniably evolved since the Constitution was first drafted, and there have been many changes over the 100 years. And the evolution has gone well beyond the 8 successful referendums which have amended the actual text of the Constitution. Of course, this number may increase to 10 through the proposals currently before the community to recognise Indigenous Australians and local government in the Constitution. And I do hope in my lifetime that we will also see a change to a republic. Beyond this, though, our Constitution is and should be seen as a living document. Without incremental and evolutionary change, often only arising from individuals challenging specific laws, but also from the evolving responsibilities of arms and levels of government, we would have a document that was fundamentally separated from the modern world. And deluding ourselves that we might at some point clarify those remaining issues in the Constitution and fix it forever in time could jeopardise the flexibility that the nation needs to respond to new social and economic circumstances. And which is why I titled my speech with a question really, a static constitution, a very Australian standoff, because the document that governs our democracy can only strictly be changed by amending the text with a strong public vote driven by clear consensus among political groups. Nonetheless, the meaning and reach of the Constitution in fact changes and evolves each and every year, driven by case law, challenges and battles over the very scope of government in Australia. So I want to talk about the role of the High Court in interpreting the Constitution and the role of the Parliament and the Executive in responding to High Court rulings, in particular using the most contemporary example of the Williams case and its implications for programs well beyond the chaplain's program that was at issue. But before we get to that, as you would be well aware in this audience, constitutional change in Australia is very rare, with only 8 successful amendments in 44 attempts over more than 100 years. And despite the actual rarity of constitutional change, it can be tempting in the face of challenging High Court decisions or a heated stoush between Commonwealth and state governments to wonder whether components of the Constitution itself might be the problem, and so changing the text of the Constitution is the solution. Again, as this audience would well know, Section 128 of the Constitution sets a deliberately high bar for constitutional change by requiring a majority of total votes cast to be yes votes and a majority of votes cast in the majority of states to be yes votes. Despite the hurdles, the Labor Party, from the time of Federation, the party of reform and progress, has shown itself willing to challenge the constitutional status quo more than all the other parties in Australia's history. Our 25 attempts stand against 9 of the Liberal and National governments and the 10 of governments no longer in the political spectrum, including the protectionist and fusion coalitions. So Labor governments have been prepared to push for change, but history also tells us of the fairly poor success rate. So we can't ignore that history. Whatever the constitutional issue, we must always approach major reform proposals with our eyes open to the degree of difficulty and its implications. Constitutional reform requires a very significant investment, whether it's taxpayer funds, the attention and effort of the community, the Parliament and the Executive are all required. And it of course should not be forgotten that this always takes place in a very congested sphere of important public policy issues, media debate and increasingly busy and pressured family lives. So constitutional reform is a high-stakes contest with a poor success rate. The potential benefits need to be carefully weighed against the certain costs. And this doesn't mean for a moment that we should never attempt reform. After all, the government is progressing constitutional change on 2 fronts as we speak. But those who advocate for reform should also carefully consider the task ahead of them too, and not imagine that this is a challenge just for government. By many measures, the most successful referendum was the 1967 referendum to remove Section 127 of the Constitution, which provided that so-called Aboriginal natives were not to be counted in determining the population of the Commonwealth, and to remove the bar on the Commonwealth legislating with respect to the Aboriginal race in any state and in reliance on subsection 5126. And I've noticed Catherine Branson in the audience here as the President of the Human Rights Commission for a couple more weeks. I know that these sorts of issues would be close to her heart, and let me take the chance, having recognised Catherine here, I'm sorry I didn't know you were here earlier, to thank her for the work that she's done over a very difficult time. It's never an easy job to head a Human Rights Commission, and you should be proud of what you've done. It's interesting and telling, I think, that 1967 referendum was the most decisive since Federation. More than 90% of voters voted in favour of the changes. The 1967 referendum was the high point for constitutional reform, but it also provides, I think, some lessons for constitutional reformers. And that is, of course, that the biggest challenge for constitutional change is to make that change meaningful for those who matter most, and that is the Australian voting public. For without widespread public support, we all know that constitutional reform will fail. And achieving this support is by no means an easy task. History again shows us that our political opponents have been expert at opposing referendum and expert at harnessing large no votes. Don't think of Mr Abbott just on the Republic, but he and Mr Reith in 1988 on local government, parliamentary terms, the expansion of the right of trial by jury, a more just electoral process, to name just a few. In my eyes, these are quite ugly examples that prove a pretty simple point. No matter what the innate merits of a proposal, referendums fail without bipartisan support. In fact, people will probably remember Mr Abbott's campaign slogan, "Don't trust the politicians," used to damn the Republic referendum. But it not just condemned the Republic to failure, it also trashed his and my profession in the process, and probably also damaged the chances of future referendums on other issues proposed by government or the Parliament. Malcolm Turnbull said at the time that it broke the country's heart. I think he might have done even more damage to the hearts and minds of constitutional reformers. Even with bipartisan support, the voting public must be invigorated to support change. reformers need to build the momentum and passion in voters to avoid the inevitable don't know, vote no movement. This is important because it means that politicians have to be active, it means that we have to be united, but it also means that that isn't enough. Civil society must be engaged and lead too, and it takes dozens of politicians to do what one school principal, one columnist, one sports star, dare I say one vice-chancellor or dean can do if they put their voice to a particular cause. And frankly, we haven't seen yet much of that leadership and engagement from the broader community on the two proposals currently before the government and the people. So this challenge awaits constitutional reformers on two fronts. That's the reform of the Constitution to recognise Indigenous Australians and also reforms to recognise local government. We've already seen efforts in both these areas to amend the Constitution fail before, so it raises the stakes, I think, even higher this time round. It's a question that, whatever its final form, particularly in respect of recognising Indigenous Australians, that frankly I think is too important to fail. So we do have to make sure that the politics does not drive this debate, that political, community and Indigenous leaders work together to build community consensus. And to help with this process, the government asked a group of eminent Australians to provide advice to us and the community as to the best way to ensure Indigenous recognition proposals that the proposal received the prominence that it deserves and that the community has access to information that they need to make an informed decision. The expert panel's report provided a proposal to make a number of amendments to the Constitution, including repealing certain sections and inserting new sections 55A, 116A, 127A. This would provide a power to make laws for Aboriginal and Torres Strait Islander peoples, to prohibit racial discrimination and to recognise Aboriginal and Torres Strait Islander languages as well as English. The panel also recommended a process for the proposed referendum, as well as a list of factors that must be considered in assessing whether a referendum will succeed and therefore whether a referendum should proceed. I understand that Professor Toomey will speak at this conference tomorrow on the flaws of the proposal put forward by the panel, which is fine. Of course, we need this level of engagement and criticism to help shape the final question to the people. But I did want to make the point that there's no point us getting the technical detail right without putting attention into winning the hearts and minds to the cause for change. Our panel recommended and the government accepted that the need for a properly resourced public education and awareness program and has committed $10 million to continue to build public awareness and community support for constitutional recognition of Indigenous Australians. This work is being led by Reconciliation Australia, supported by a reference group of business and community groups, the Australian Human Rights Commission and the National Congress of Australia's First Peoples and members of the expert panel. It also urged active consultation and support from the opposition, the Greens, independent members and state and territory governments before making a decision to proceed. It's fair to say that this part is not going so well, despite our attempts. It is a shame, I think, that there is some DNA in the Liberal Party that has not been shaken and that negativity has kicked in again. Senator Brandis, in fact, has said and made, I think, an active choice to play party politics at this pivotal moment, that he supports the referendum but it shouldn't proceed under the current Prime Minister. I've been struggling with how that exactly works. Of course, I don't agree that we should have this serious issue brought into the partisan daily politics. It will hardly help ensure its success. But I don't understand, if you would support this proposal with another Prime Minister, what possible logic there is of saying no now, other than possibly spite. And I think it's hardly edifying. If people do want this reform to work, a referendum to be put and to succeed, then we do have to find some way to come together, to work together. And I've been heartened to hear the words of people like Ken Wyatt, a Liberal MP, our first Indigenous MP in the House of Representatives, who strongly supported Indigenous recognition in the past. The government's also made a commitment to pursue a referendum for the recognition of local government in the Constitution. It's of note that both past attempts in 1988 and 1974 to recognise local government have been unsuccessful. And while the government has made this commitment, my colleague Simon Crean, who is the Minister for Local Government, stated recently that given this history, it's clear that we need to be confident that support will come from a broad base of the community. There's a very real prospect, again, that if we proceed and lose, that would be the final death knell for local government recognition within the Constitution. Future governments will just not waste the time and effort on a fourth attempt. The expert panel was chaired by Jim Spiegelman, the former Chief Justice of the New South Wales Supreme Court, and it did identify uncertainty around financial payments directly to local councils as a key factor for supporting the case for recognising local government in the Constitution. And local governments themselves have been very keen supporters. Again, it's true to say that the states have been a little less enthusiastic. I think it might be an interesting test of the community's engagement with our different levels of government if such a referendum were to be put forward with bipartisan support at the Commonwealth level and opposition at the state level, although I suspect I might be getting ahead of myself there. The recent High Court judgment in the Williams case certainly adds a layer of constitutional context to that question. The decision did not, as some had predicted, rule out the possibility of government spending directed to local government bodies, but it has perhaps given some extra weight to the arguments for change. Leaving aside the explicit changes to the Constitution through referendum, let's also turn to the way constitutional arrangements evolve, or at least adapt, over time. Some changes occur in practice, such as the referral of the corporation's power, and are not challenged at all. They're accepted by government players as they're agreed, or they suit all interests. Others occur incrementally. For example, the postal and telegraphic power provided for by subsection 51(5) of the Constitution, for example, has been construed as a power over many forms of modern electronic communication, while others occur gradually over time, such as the Commonwealth's expanding tax base and resulting fiscal power in relation to the states. And of course, the opportunity to challenge laws with the consequent possibility of developing constitutional interpretation has expanded as the amount of legislation brought forward in an increasingly complex society has expanded. From the 232 total number of acts in 1910, we jumped to 2,500 in 1950 to 11,717 at the end of 2011. So governments of all persuasions have sought to regulate and respond to an increasingly complex Australian society. The opportunity has expanded in that there are more laws a person might challenge, but in the vast majority of cases, there is not an agitated or cashed-up litigant to test each and every interesting question or borderline exercise of power. I think this is important in the context of the Williams decision. This case was brought in protest about a religious presence in a state school. According to all of the public and media reports, what motivated, indeed incensed Mr Williams was what he saw as an encroachment of church into state matters. Ironically, the only thing upon which all the High Court judges agreed was to reject this particular argument. But in bringing the challenge, Mr Williams has instigated a fundamental change to the way governments must set up programs that involve expenditure. In the event, many of you will be familiar with this, of course, the High Court judgment invalidated an agreement made by the Commonwealth under the National School Chaplaincy Program by a majority of 6-1. But you might also be aware that the majority itself was split, with some judgments suggesting a greater prospect that the court may in the future find that Commonwealth spending must be tied to a particular head of legislative power. However, despite the commentary signalling this as a definite direction of the future, or even a consequence of the decision, this was just a flag by some judges, and the case did not decide this matter. As an aside, however, I might tell you that these sorts of ruminations are the ones that present the odd headache for governments in planning sensibly and carefully for the future. Such a split, even amongst the majority, made the decision more difficult for government lawyers in the immediate aftermath, but I anticipate that it will prove a boon for PhD students over coming years. As it does for all major impending decisions, the government had conducted extensive contingency planning for a wide range of possible outcomes in this case, and the importance of the government's contingency planning was immediately clear. The Williams decision overturned the understanding on which the Commonwealth had acted since Federation, that the Commonwealth could develop and administer spending programs without the need for legislative authority for these programs. In Williams, a majority of the High Court held that legislative authority is necessary for certain spending. So the Williams case has significant implications for the validity of forms of Commonwealth spending programs or national reforms initiatives that haven't traditionally been supported by legislation other than an Appropriation Act. From the most recent Commonwealth initiatives, such as the establishment of the National Mental Health Commission to drive system improvements for the benefits of millions of Australians living with mental health difficulties, to long-running programs such as veterans' commemorative activities and the maintenance of war graves. The Court was clear that not all spending is affected, such as the ordinary services of government and arrangements with states. But thanks to our preparation, the government was able to respond swiftly to the Williams decision and enacted legislation within 8 days of the judgment to ensure that legislative authority was put in place for hundreds of potentially affected programs. This involved extensive meetings by myself and my office with parliamentarians from across the political spectrum, drafting in shifts by the Office of Parliamentary Counsel in consultation with the Attorney General's Department, the Acting Solicitor General, coordination by the Finance Department regarding affected programs across all agencies, to complete an administrative and legislative process in just over a week, a process that in many circumstances would take 12 months or often much more. So I do ask, who says the Parliament is hopelessly deadlocked? I thought that was quite impressive, really. I like to think of the result as being extraordinarily efficient or sensibly pragmatic, but I have to tell you I think it was a bit lucky too. Had Parliament not been sitting for an extended time, what would the public officials spending money on these other programs actually have done? Community and building programs may have ground to a halt, people could have been unpaid, and I think these consequences were a long way from Mr Williams' concerns about his children's secular education. But this is only the most recent case in a long history of cases fought on one issue and having extensive consequences for others. Aside from pointing to the need generally for governments to adopt a prudent approach in preparation for potential challenges, this judgment and the rapid response graphically illustrates the breadth and impact of constitutional interpretation by the High Court and the Parliament's role as society's elected representatives in responding to decisions. As I said, I think this decision is fertile ground for in-depth analysis and will support many a thesis in the future. But my brief contribution today is really to note that on occasions where a judgment goes to the core of constitutional questions, particularly regarding the operation of the executive government, it may be necessary for governments to put forward legislation for the consideration of Parliament to address the judgment. In this case, the Court made clear that the constitutional flaw was the lack of express parliamentary approval for spending on this program. The cure to this newly identified flaw was to pass such legislation for this program and for the many others arguably in an equivalent position. And I want to emphasise here my strong view that this exercise is neither an affront to the Court's decision nor the Parliament stepping beyond its bounds. In fact, in my view, it gives great deference to the Court in acting immediately to address the concerns raised by it. The Commonwealth and Executive and the Parliament have a responsibility to exercise judgment and react quickly following important decisions that have broad consequences. Where necessary and possible, they should act to ensure the government continues to operate within constitutional guidelines that have been provided by the Court. And this is simply the natural dynamic of interaction between the Executive, the Parliament and the Judiciary. The Williams decision was not the first occasion on which a government has needed to respond swiftly to a significant High Court decision, which has challenged the government's understanding of the Constitution's requirements, and it won't be the last. It's simply the most recent demonstration that the meaning of the Constitution is a matter that can never be taken to be settled, no matter how long the Executive of the day may have wished it so. The Act passed following the Williams decision addressed the new requirement identified by the High Court, as I mentioned, that there must be supporting legislation for programs, and provides now a legislative basis for over 400 existing programs, some of which have been running for many years. These programs comprised a significant portion of government expenditure. And to just give you a couple of other examples to add to those that I'd flagged, they supported things like eligible primary producers and small businesses, with free financial counselling to manage adjustment pressures and remain viable. In this financial year, that costs around $15 million, a focus particularly for rural services. Programs conducted in my portfolio under the auspices of the National Counter-Terrorism Committee that support the coordination of nationwide counter-terrorism capability through actions including the delivery of training, the conduct of exercise activities and the purchase of specialist equipment. I really just flag those because I didn't think you'd want the list of 400, but really to give you the sense of the range and breadth of programs that were affected by this decision. Of course, also to recognise that constitutional interpretation is undertaken by the High Court is integral to the meaning of the Constitution, is by extension, of course, recognising the very important role of the individual judges within the framework of the Constitution and common law as it's developed in Australia. And I notice that we have the Honourable Justice Dawson here as well, one of the judges on the High Court when I was lucky enough to be an associate. Of course, from its inception, there have been allegations that High Court appointments have been made by governments in the hope that future decisions will trend towards their general view of the world. And more than once, this undercurrent has become overt, particularly in attempts to address perceived judicial activism. I think it's a testament to the strength of the court, and maybe to human nature, that so many governments have been left disappointed by their appointees' subsequent decisions. I need only mention William Dean, appointed by the coalition government, perhaps hoping his quiet, modest and religious nature indicated a conservative. But as Justice Kirby stated in reflecting on the appointment of William Dean, and also I think Chief Justice Mason, the appointing governments probably expected, in Justice Kirby's word, capital C conservatives. In fact, the C ought to have stood for creative. Justice Dean turned out to be one of the most creative and progressive thinkers on the court, and as you would be aware, with Justice Gaudron, co-authored the famous judgment in the Mabo No. 2 case. Of course, Justice Dean was then made Governor-General by Prime Minister Keating, just to highlight how perceptions can change. I make these general comments, of course, in the shadow of 2 upcoming vacancies to the court, and to assure people that our key consideration will be to identify the best legal brains in the country. For all the speculation, I am not naive enough to think that looking for anything other than brilliant lawyers would be wise, or indeed effective. I have asked for and received many nominations from diverse areas of practice across the country and with different experience, and it's given the government a wonderful pool of candidates to consider. And given that Justice Gummow retires in October, we'll be soon making an announcement about his replacement. That's not a scoop I'm making today, however, at this conference. So just to conclude, despite the rigidity of Australia's constitutional arrangements from a textual perspective, it can't be doubted that those arrangements are resilient or that they remain adaptable to broad-based developments in Australian society. Cases like the Williams case remind us that it can never, and never should be, thought of as a settled, final and beyond new interpretations. While this inevitably creates problems for governments of the day, this evolution is also what allows us to keep the Constitution relevant and responsive to Australian society. And we must remember that it's governments and government practices that change too, often inviting new approaches to be tested in the courts. So even if constitutional reform is defined strictly as constitutional amendment, there have been important successes. But the reality is that constitutional reform in this strict sense can only be achieved where there is broad community support for constitutional change. The government believes the time has come for changes to reflect the important place of Indigenous Australians in our society and the significant role of local government. However, the Constitution leaves no doubt about one issue, and that is who is responsible for changing Australia's fundamental legal document. And it isn't the government, and it isn't the court. It's only the Australian people voting at a referendum who can bring about such a change, and it will be very interesting to see if they do so. Thank you.